Hello, my name is Bob Barker, and welcome to today's webinar. It's part of our GC Advantage program, and we have a couple great speakers today, and appreciate you joining us. Today's topic is managing through crushing litigation and disruptive M&A. We have some upcoming webinars that you'll see here. The next one is going to be preparing for your first year as a general counsel. The one after that, the following month is doing more with less, managing work and development, developing talent with ever tightening budgets. And then the one in June is going to be building, mentoring, and coaching diverse teams. So if you go to the next slide, Taylor, we are going to take questions. Throughout the event, we'll be answering them at the end. So to submit your questions, just use the Q&A button at the bottom of the screen on the Zoom platform, and you'll be able to see other questions that the people have submitted. And if you particularly like one, you can give it a thumbs up rather than having to type in a separate question. And basically, we'll see the questions that are most popular. And so we can address those first at the end of today's session. And if you are having any technical issues or what have you, that's what the chat feature is for. I think that kind of covers the intro component. So let me turn it over to Mike Williams here.
Oh, thank you, Bob. Appreciate it. And good morning, crime fighters that are on the West Coast, and good afternoon to you on the East Coast. I'm Mike Williams. I'm a senior advisor here at Barker Gilmore, and I'm also the former EVP and CLO at Staples. And before then, I was the general counsel and EVP at Sony Electronics here on the West Coast. Prior to that, I was 22 years in private practice in Los Angeles, starting my career at Gibson Dunn and ending it at Heller Ehrman. So in the time that I've spent in private practice, as well as my years in-house, I've got to observe and see a lot of things about crushing litigation, mega deals. And one of the people I was very fortunate to work with during that time was my partner in crime, who helped me defend the righteous from the misguided, and that's Lisa Ropple. So I'm going to turn it over to Lisa so she can introduce herself. Lisa?
Thank you, Mike. It's really great to be here today. As Mike said, my name's Lisa Ropple. I'm a partner with Jones Day out of Jones Day's Boston office. And I'm also very privileged to be the co-practice leader of Jones Day's global cyber privacy practice and head of litigation in our Boston office. I focus my practice on helping companies respond to big cyber events and preparing them for those kind of incidents, also helping them and representing them in connection with investigations and litigation that often follow significant events. Before I joined Jones Day, I spent 5 years at Staples, where I got to meet and work with Mike, who is truly a general counsel extraordinaire. I'm not exaggerating. He was wonderful, and it's been great to work with him. I'm very fortunate to have had that experience. I was head of litigation at Staples, and at that time, Staples was in 26 countries around the world. Mike and I encountered a number of very significant litigation and government enforcement matters while we were there, matters that were making headlines in the US and in the EU. We also encountered 2 high-profile cyber incidents during that same time, which were not technically in the job description, but we faced them anyway, and those also made evening news. So we have some firsthand battle experience to share with you today. Before my in-house stint, I was a litigation partner at Ropes & Gray in Boston. I was there for the magic number of 22 years. And I focused on complex business litigation and government enforcement there, and also co-founded the data breach practice. Back when there was no such thing as data breach, we happened to handle one of the very first mega breaches there on behalf of TJX companies and worked on mega breaches thereafter. Looking forward today to sharing with you some of the things we learned. We're going to sound like we have it all in the box and we know how to do all of this, but some of this is stuff we did right, and some of this is stuff we realized on the back end we could have done better. So I don't want to minimize the challenge that's ahead of all of you, and we're just hoping that some of our experience helps you navigate things that you very well will encounter.
Right. Well, thank you, Lisa, for those kind words, and your check's in the mail. Okay. But no legal presentation or any presentation that Lisa and I do would not be good without a disclaimer. So these are the views are ours only. They're not reflecting of Jones Day or Barker Gilmore or any previous organization that we were affiliated with or clients that we may have served in our prior life. But we're going to share on a generalized basis our experiences and the lessons learned. So the way we're going to do this is we're going to cover the topics of assessment and then final thoughts. Now, the assessment part, I think you'll find the common theme throughout this is going to be preparation, proactivity, looking around the corners as to what you can anticipate you're going to have to deal with. So we'll take you through a few of these typical ones that we've had to deal with in the past, but also give you the methodology on how we approached it. And looking back, like what Lisa said, like some of the stuff we knew, some of it we learned along the way, but looking back in times, like why were we successful? How could we have done something better? And that comes down to assessments of ourselves, our organization, assessing the audience you're dealing with in their level of participation, because that will demand, that puts the demand on your time as an in-house lawyer. And then finally, some winning attitudes and behaviors that help you get through multiple events all at the same time, and some final thoughts. So with that, I wanted to mention that we're going to talk about assessment, because when I look back when in Lisa's career and my career, how could we handle a data breach with an activist shareholder campaign at the same time, or a multi-billion-dollar divestiture at the same time of dealing with CEO succession? Well, I think it's, you start off with assessing yourself and the organization and how that will handle different types of events. So the first question I always ask myself, what is my experience in the area? Second, who do we have in-house on my staff that could help me navigate these problems? The third question you should ask yourself as a sitting GC, deputy GC, or in-house lawyer, who have we retained? Who do we have on speed dial? The next question is, what do we need? If I do have a cyber breach or a big time litigation or a hostile takeover, what do we need as a company? And who do we know to get us those resources? And then finally, sometimes, not on every event, but looking at others, how do we compare? Is this the best practice? Are other people in a similar situation? What have they done? What were the end results? So with that, I'm going to take you to what's something very simple, and that's a search warrant raid. Now, you'd say, Mike, why are you focusing on search warrant raid? Well, let's look at it this way. At Staples, Lisa and I had 68,000 employees, fellow associates. If you're in a town in America with 68,000 people, you're going to have a police department and you will have a jail. Why? Because in 68,000 people, there are going to be criminals. There's no reason to think that in your organization, you have all the angels working for your company and there are no bad actors in the warehouse, in the fulfillment center, on the retail store floor. You never know. So what happens if the FBI, the district attorney, CBP, OSHA, they show up with a search warrant to grab materials to interview your employees unannounced? Well, I go through this and I'm thinking to myself, okay, what's my experience in the area? I was never a criminal defense lawyer. Yes, I was a rented DA for 1 month in Los Angeles when I was an associate, but that was involving prostitution and drunk driving cases. So I'm not a criminal lawyer. Who do we have in-house? Well, I didn't have any assistant U.S. attorneys or former AUSAs. I didn't have DAs. Even if I did, I'd be asking myself, were they in criminal operations opposed to consumer protection, consumer fraud, or civil? And then finally, who have we retained? Do we have anyone on call? A criminal, a white collar criminal defense lawyer. You may have securities lawyers to help you with your SEC filings, but that's not the same thing as dealing with an SEC fraud investigation. What do we need? Well, I identified the need both at Sony and at Staples that we should have criminal defense lawyers on call, if necessary, in those jurisdictions where we operate, because those lawyers will know the local prosecutorial agencies. And that's what we needed to do. So how do we do this? I asked around. I'd asked Lisa, who was an experienced practitioner from Boston, who in Boston are good white collar criminal defense lawyers that know the U.S. Attorney's Office, that knows the DA's office. We would identify them and have them on call. And how do we look compared to others? I asked my fellow GCs, do you have a booklet or how-to manual at the reception desks of your offices, at your warehouses, so that if the FBI or the sheriff or the DA shows up, you know who to call and what to do? And do your lawyers know what to do and what to say? Because remember, if someone calls downstairs from the lobby and says, Mr. General Counsel, there's a guy here from the FBI with a search warrant for the CEO's office, what do you do? Well, the first thing you can't do is say, gee, let me call Lisa. She has any white collar criminal defense lawyers. Maybe I can get 20% off their regular rate. No, that's not the question you should be asking. What you should be saying is turning to your executive assistant, say, get me Mike Adonacio on the phone right now at Cooley, because he was retained, he knows what to do. That's what we were ready to do, like at a Sony or other places. So that's how I went through this assessment, being honest with myself and my own organization's capabilities. So with that, I'm going to turn over to the next one, which is Lisa's specialty, and that's cyber.
So thanks, Mike. So just to compound here on the theme of advanced preparation, at this point, it's really predictable, actually, that companies will have data breaches. You have to plan for it. It used to be 15 years ago, 20 years ago, that it felt like a lightning strike. It's no longer the case. The question isn't really whether you're going to have an incident, it's how big and what type. And so advanced preparation is key for a number of reasons. First, most cyber incidents, if they're significant, are hugely impactful or could be. They can damage a company across the board. Operationally, they can shut down your systems or impede your systems. Right now, we're seeing just onslaughts of ransomware for the last 18 months that are just crippling companies globally. Companies you wouldn't expect too, in industries you wouldn't expect to be targets. Reputationally, your reputation can be tarnished literally overnight. Financially, it costs a lot of money to investigate these incidents, let alone to respond to them fully and to handle the legal fallout, which can be a long tail of 4 years at least of litigation and investigation. So high stakes, potential impact, and two other factors make it really infeasible to respond without advanced preparation very well. One is that there's laws that apply to cyber incidents that may require you to provide notification very quickly. In the EU, for example, you have to notify within 72 hours of discovering a breach involving personal data. That's really fast. And so once you go out with notice, especially, you're going to be in the spotlight and everything that you're doing may be public. That adds to the pressure and increases the need to have advanced preparation. You just can't build an airplane while in the air. So with that, how do we prepare? What do we think about? Let's go through Mike's methodology here. First, what's my experience? Well, it's not common to have extensive experience handling large data breaches in-house. You wouldn't expect to. Mike and I just happened to have a lot of data breach experience, but it was sort of uncanny. And I think both of us were hoping we wouldn't need to use it when we were in-house, but it turned out we did. But even if you have that,
I still thank God that Lisa was there when we had our data breaches. Thank you, Lisa.
You're welcome, Mike. I was sort of, well, anyway, I'll leave that aside. But anyway, even if you have some experience with one or more big data breaches, you may not be completely current. The regulatory landscape is changing very quickly, as is the threat environment, the types of attacks that are happening. And so you're probably going to need to bring in outside resources. What do you need in-house? What should you be looking for there? What you really need is a very strong team lead, someone who can quarterback the response, because incidents require really 24/7 if they're a significant incident, and you're going to need someone who's a hands-on, good leader, able to coordinate across functions within the company, many of which may have very different perspectives and will need to be harmonized. And you need a really good communicator and someone who can handle the outside vendors that I'm going to talk about in a second and the internal issues and bring it all together in a structured way. So in terms of internal expertise, you got to look for your lead. Externally, who have we retained and what do we need? Well, really three prongs to this one. Typically, in a significant incident, you need outside counsel someone who's been there before, done it before, a muscle memory on how to come in, structure this efficiently, and help you identify issues that you may encounter that you might not have thought of. Forensics, you need outside forensic folks, not necessarily because you don't have those capabilities internally, but you may need more resources than you currently have. Your internal people may be overwhelmed with trying to contain and remediate, not necessarily look backwards at forensics. And also, regulators and litigants will accept the results of your investigation with a little bit less cynicism if you have an outside forensic vendor provide those services. So forensics number 2, and then third, crisis management. Again, this could be one of the biggest events your company faces, and many companies like to involve crisis management firms. Now, you can line up all of those vendors in advance, and we recommend that you do. I just want to mention 2 considerations that really bear on this. That one is pretty unique to data breach and should be thought of. It's something that most practices and companies have not caught up with the law on, so I just want to alert you to this issue, and that is forensics. So as cyber incidents have become well known and preparedness has become a sort of buzz term, a lot of companies, quite understandably, have had their IT departments vet outside forensic vendors and line them up in advance with a contract. They have them on retainer. There's been a line of cases in recent year or so, however, where courts are saying, if you do that, you're going to have a lot of trouble later on claiming that any work that forensic vendor on the outside does is privileged, even if you have your outside counsel direct them. And so we are just very strongly noting this for everyone, because what was sort of state of the art is now not necessarily helpful from a legal protection position. And we recommend that you, in advance, pick out your outside counsel, have your outside counsel identify a forensics firm, vet that forensics firm, line it all up, have contracts done where the outside counsel retains the forensic firm, contracts ready to go. You can literally sign them and be off to the races if you need them. But that structure, setting that up in the midst of an incident can be really very time consuming and can delay your response. And we want you to maximize privilege. It's a really important component to minimizing your downstream liability flowing from a breach. So that's a really important consideration I want to mention. And the other one is that you may have cyber insurance, and it'll be important to have your cyber insurer approve your vendors in advance as well. Again, another possible delay point if you don't do it in advance. So that's kind of who've retained, what do we need? And then the next question is, well, who do we know? So before you need them, take the benefit of time to really do your research here. And we recommend you think about 3 things when you select your outside counsel in particular. First, you need to kick the tires and make sure they have actual experience. Cyber is still a bit of an emerging area, and a lot of people are out there. Every firm will tell you that they do it. Really encourage you to drill down and make sure that the experience of the team you select is deep and broad and recent. Second, client service. You're going to want a partner in the trenches on one of these matters. It's 24/7. Your CEO is going to be engaged, your board's going to be engaged, and you're really going to want to make sure that this isn't going to be something that gets delegated to a junior associate. While there's a role for them and efficiency is important, this is the time that we want a trusted advisor. And so you really want to make sure there's a commitment to the client service aspect of data breach response. And then finally, pick someone who's going to interact well in your company, who's going to have credibility and presence and communicate in a style that will jive with your board and your senior execs and your IT folks. That's really important because there's going to be a lot of technical mumbo jumbo coming at them. And you're going to want someone who can translate that into digestible, executive summary, business ready kind of points for your business team. And that can be hard to find, especially when high-tech issues are involved. So final question, how do we look compared to others? Well, this will be a really important focus of senior management and the board in particular. They'll want to know how other companies encountered things. Our advice to you is that you respectfully acknowledge and be prepared for this and then completely ignore it because it's not going to help you. I'm pretty sure when you've been pulled over on the highway speeding, it has not helped to say that guy's going faster. Same thing on data breach. If you have a big data breach, you can pretty much be assured that there's a high likelihood you're going to get a regulatory inquiry or an investigation and some litigation. Doesn't matter what other people are doing, you just got unlucky. And so it's best to really focus your resources on preparing for that and not getting too distracted with what everybody else has done in similar circumstances.
And just to amplify 2 points that Lisa made. One is on in-house capabilities, someone that you can rely upon to quarterback, to take the lead, to work across functions. That's very important, particularly if you're dealing with multiple events at the same time, because GCs, you can't do it all, okay? You only have so much time in a day. And so you want to have, if you're lucky enough, a person like a Lisa that's working with you that you can rely and trust, saying, you know, I know she can communicate and deal with this issue while I deal with the board on the activist shareholder campaign, or deal with the comp committee on the say on pay vote, or whatever that may be the hot button issue at that time. And also, when we talk about preparation, when you look, you have the time and luxury to vet outside counsel, because you may think on paper, this person is great and they're knowledgeable, but then you meet them and they could piss off a Care Bear, and that's too late in the game. So you really do need to take the time and get that kind of chemistry going, and someone that can explain to the board, to senior executives, how this all gets together and not do it in a pedantic manner. But, and I'm going to share, but Lisa's going to share with you what we thought the cyber events look like to the in-house lawyers.
Yep, there you go. That's what it looks like when you have a data breach. We just tried to bring, order to it, but in the first 24, 48 hours after a breach is announced, this is what crawls at you through the swamp, right? And it's a lot of alligators looking, they're all hungry, they're all coming at you, they all think they're the biggest and most important alligator, and they're all looking for flesh. But we wanted to remind you that when you're dealing with this kind of a issue, your job is not to wrestle all the alligators all at once. Your job is to figure out which are the most voracious and which present the greatest risk to the company, and then help prioritize those risks and harmonize them and give direction to the company about really which ones are the worst in the swamp. So survey the swamp, don't get overwhelmed, and don't wrestle all the alligators.
Right.
All right, turn it back to you, Mike.
Yeah, and to think about that, just over looking at these alligators, is that just remember when you're, the presence of mind that your job is to survey the swamp, and think about all these alligators that Lisa and I had to deal with. But the most important alligator long-term is the one labeled customer, because it's customers that will put your company out of business if they don't think you're doing the good job in handling a data breach or a cybersecurity incident. That's the bottom line. Government agency is not going to put you out of work. They may fine you, they may do some other things, but it's the customer. And if you keep that as a touchstone in your analysis and your work, it also helps make you organize and prioritize the workflow. And the same thing if we next go on to like an activist shareholder campaign. Again, I'm not going to walk through each element for myself or for Lisa, but I do want to point out that probably the third element, who have we retained? If you think, and your investment banker should be talking to you about this, that you may be subject of an activist shareholder campaign, your company, you're sitting on a lot of cash, you're not a market leader, you're underperforming your peers in the marketplace, the typical kind of profile that activists look for, you're going to have to say to yourself, who have we retained? You should have already interviewed investment bankers, crisis management communication firms, proxy solicitors should already be on board if you don't have one, and also specialized counsel, because this is not something that everyone can do. Just like cyber, there may be a lot of posers out there, but there are very few actual real players. And take the time, because when we were subjected to an activist shareholder campaign, we had already done our homework. I could reach to my shelf, pull out a playbook, and know exactly who to call, what we're going to do, when we're going to meet. We had holding statements ready to go. We didn't have to worry about getting together and drafting in a war room. What do we say to the investment community when someone discloses that they've taken a position in the company? We had it down to a science where we even had the names of the catering companies to provide us food in the war rooms. All right. That's the type of preparation you should take and do now with one or two of the board members involved. But definitely, if you haven't done it yet, talk to your CFO, talk to the CEO, like, should we do this? I think if you think you may be subject to it, now's the time. because once one campaign is launched, you're going to have a lot of alligators nipping at your heels, and something similar to what I call big time litigation, which again, Lisa and I had to handle multiple cases at once. But, again, I'll let Lisa walk us through what are the important areas to focus when you assess yourself and your organization. Lisa?
Right, thank you. So with litigation, that one's a little bit more comfortable, right? As a GC and in the legal department, you can expect your company is going to get enmeshed in some litigation and occasionally some high stakes litigation. So you probably have experience handling litigation, even if you have a transactional background. Once you're in-house, you know how to think about these things and you know how to boil them up for internal consumption. That's critical. What I really want to focus on, though, in the interest of time here, is to talk a little bit about what you need, right? So, well, what you've retained and what you need. So on the retained side of things, yeah, you have to wait a lot of times for some litigation. It comes in, it's unusual, you can't really anticipate it, and you're going to have to select counsel in the context of getting sued. But more often, there are buckets of anticipated litigation where you can get to know counsel in advance and think about who you'd like to retain earlier before the claim hits. Some areas there I'd like to just emphasize that work for me anyway. General business disputes. Who's your go-to commercial litigator? You're going to have a contract fight. Who's that going to be? IP can often be that same type of thing. Class actions in labor and employment, wage and hour class actions, predictable. A lot of folks out there, you want to vet them in advance. Non-competes, you might have to move fast, so you want to line someone up there. Antitrust could be a concern, securities litigation, and of course, cyber and privacy, where privacy is really becoming the #1 emerging risk area. I really encourage you to think about that, especially because there's not a lot of firms with privacy litigation experience. It's sort of a new area for many, and cyber litigation. These are things you can line up in advance. I recommend you do it. So what do you need internally? Well, 3 things I want to point out that we found to be very important to focus on in connection with big ticket litigation. #1, goes without saying, but people overlook this a lot. Make sure your legal hold process is sound. It's really a high risk area in-house. If you don't implement a legal hold in a really effective way, especially on the IT side, these days in-house lawyers really take the heat for that and fall for it. So make sure you're familiar with what your IT department is doing now. There's sometimes a gap between your understanding of what they're doing and what they're actually doing. Stay current on that. Make sure your processes are defensible. Very important. #2, when cases come in, it's really important to have an effective intake and early assessment process. A lot of times, cases that come in the door don't look that scary at first, but sometimes some of your biggest risks can percolate there. Note in particular here, subpoenas, they could look innocuous. They could be hiding a key TAM action. So just really, really watch that and make sure you have a defensible process that escalates matters for attention of people beyond the intake person. So there are no surprises on the management side, which is really the mantra, no surprises. And on that same theme, while handling the big litigation matter, make sure to come up with devices and techniques to keep folks informed. Don't let it fall off anybody's radar screen. Regularly communicate, over communicate, and communicate in a way that business people can hear you. I think the least effective thing you can do is go to a business unit head and tell them about a motion to dismiss and the pros and cons of a summary judgment motion. You don't even know what the hell you're saying, right? So what you have to boil it up to, here's what the issue is, here's what the risk is, here's the possible outcomes, here's the recommendation and the options. You pick. And in fact, on my team, I had a rule that everybody had to do a 1-pager. If they couldn't get those principal points in an optically, a visual format, not a lot of text on 1 page, then they weren't ready to talk to the client. And I really encourage bringing that kind of discipline and executive summary communication skill to managing the big ticket litigation. Finally, who do we know? You ask around. You can look at cases that are published in certain areas. It's always good to look and see how similar cases were resolved. It can help set expectations internally and give you a sense of who is really capable in this area. All right, with that, I'm going to turn it over to you, Mike.
Yep, and one thing, who do we know in terms of litigation? Also, be aware that you may times be subjected to home cooking, which is you need the local attorney, because you may have the outside counsel lined up, the big national firm that can handle it. But if you find yourself in Johnson City, Tennessee, or in Liberal, Kansas, you better have a local lawyer working with your outside counsel in representing you, because that's always something that people overlook. You can't always anticipate where you're going to get sued, but at least in your checklist of things of how do I handle this event and how am I ready? That's one thing we could do. So then we go on to the mega merger, mega deal, or even a hostile takeover, and some kind of big corporate transactional event. So again, you have to ask yourself and be honest, what's my experience in this area? Were you a partner at Paul Weiss in New York City, or Sullivan Cromwell, and you were doing big deals? Or were you a fifth-year associate in a corporate department in Kansas City, Kansas, where you did some large deals, but nothing of that nature? Who do you have in-house? Again, look at your staff, look at the in-house lawyers that you have. What is their experience level? And I may have forgot to mention it, but we do recruiting for companies. So in case you ever have the need, all right? But who do you have in-house? Then who have you retained? Are they familiar with your deals? Are they familiar with your company culture? Again, how do they interact? Again, it's the personal element of that partner interfacing with you, the GC, keeping you in the loop, and how do they interact with the business people, the CFO, et cetera. One thing I always find myself is saying, what should we do in terms of the in-house lawyers? I always look to make sure that my in-house business lawyers that are supporting the deal people, they're tight. They know what's going on. They're hand in glove all the time, because they're the early warning system for you, the GC, if you know something big may be coming down the pike. And if it is coming down the pike, what do you need? You need to avoid creating bad documents. All right. And when I say that, I'm talking about your outside investment bankers, your business consultants. I swear at Harvard Business School, they teach those students that are going to work for McKinsey and BCG, use the word dominate, own the market, control pricing. I mean, those are bad PowerPoints. You want to get in early and have your people sensitized that if they are going to do a presentation to the board, to the CEO, to the executive committee of the company as to why this deal makes sense, make sure it's vetted by your deal guys, your lawyers, so they know that those words don't show up in the final drafts. That's why it's important that your lawyers are tight with the business people. And then finally, how do you look towards compared to others? Again, what happened in the similar deals? Did they go through? Were they blocked? Did it cause shareholders to get upset? Did it cause for a competing bid? It's things like this that you have to think about and be proactive in your thinking. Again, as I talked about earlier with Lisa, you have to look around the corners as a GC to anticipate how to handle this event along with others, all right? So then after we do the mega deal, mega merger, hostile takeover, whatever you call it, we talked about earlier about assessing your audience and their level of participation, because we'll find out that audiences vary depending upon your problem. And not all audience members are equal. Just like George Orwell in Animal Farm, not all animals are equal. Some are more equal than others. Same thing with a deal or a cyber break. There are different audience members. Not all audience members need to participate all the time. You have to be aware of this and be disciplined. Make sure that your audience members don't cross their eyes. And what I mean by that is they should not confuse being informed with being involved. So early on any type of matter that you're dealing with, singly or simultaneously, make sure that the audience members know that they're in the information mode or the involvement mode. Most people are pretty good at swimming in their lanes. Occasionally you get a C-suite executive that wants to swim the entire width of the pool. That's what you've got to get in early and say, this is how we're going to do it. All right. And that will dictate how much time you're spending with that audience member. How do you communicate effectively with the audience is another one. Different audiences need to receive their messages in different manner. And then also, finally, understand and appreciate your audience's perspective. The old expression that, perception is reality. There are going to be audience members who think this is really, really important, very important. And you, a lawyer, thinking through the lens of a lawyer or looking at through a lens of a lawyer, it's not that material, but appreciate and understand your audience's perspective, because that will inform you as to how much time you're going to take on that matter. So to run through some of the highlights of what we've learned, Lisa's going to talk about cyber incident data breach in the audience that you're going to deal with.
Yeah, real quickly, in the interest of time, I'm just going to highlight that you will have lots of audiences if you have a data breach. Every single person in the company is going to want to know about the data breach. A lot of people outside and a lot of alligators outside the company are going to want to know about the data breach. So getting people's attention and having an audience isn't a concern in a cyber incident. It's more Mike's point that you need to figure out who really needs to be involved. And you'll find that everybody who is interested, whether they expressly say it, and they probably won't, or not, they often have a question about their own personal exposure or potential impact of the incident on them. And that really does color their view, and it probably should from where they sit. It's not a criticism, it's just a reality. So you just need to have your antenna up for this and try to address the perspectives of these different constituencies in a way that enables you to build trust and confidence with each of them. So the board of directors, in my experience, they're going to be very interested in their own personal liability. They're going to be wanting to make sure the issues behind the company, but they're going to want to make sure that notification is given really promptly. They don't want any delay to blow back on them. Very important to the board. The CEO will be interested in those same things too, but he's going to be or she is going to be very focused on containing the incident and making sure the business impact is limited. Also, again, behind the scenes, might be thinking, what's going to happen to me in the wake of this? There have been some impacts on CEOs after large data breaches that have been reported. Senior management, everybody's going to want to be informed. Many are going to want to be involved, and most will be thinking about how to solve the problem from their business unit lens. So, if operations are down in their unit, they're going to want them up. They're not going to care about other units that might be higher priorities for the company. So you have to sort of manage that. ITIS, very critical audience. They may not understand why there's forensic investigation teams involved that aren't them. They may want to control the investigation, may not understand the privilege point, and they may be concerned that they may be blamed. This is a really key point to sensitize you to, because this is where we see the best emails created for the company. There's very few breaches that I haven't seen an email from someone in IT saying, oh, by the way, just as an aside, I think this breach happened because of this widget that could have been closed for $25, as I mentioned last year when I sought budget approval for this very issue and warned you that this could occur. So you will see those emails, and you've got to be really proactive about making sure that you engage with ITIS, establish trust with them, and help them, just sort of manage these perceptions and help them understand so they don't feel in a corner. And then finally, employees are always going to feel like you left them out, that you should have told them earlier, and they're going to want to know the impact on their data.
Right. So then, taking on the same theme here in terms of audience for an activist shareholder campaign, this is more along the line that you should appreciate the different perspectives that you're going to deal with your audience and the time it's going to impose upon you. The directors may view this as unwarranted criticism of their tenure as a director and a direct threat to their business reputation. Now, that's personal to them, not really to the company per se. So, but you've got to be sensitive to it, right? And more importantly is if it gets a nasty campaign and the activist starts taking pot shots at directors like, oh, they've been along forever, they don't do anything, they just collect a retainer, you got to have, someone's got to have a difficult conversation with that director that they may be vulnerable. And unfortunately, that's why you have outside counsel and investment bankers, because they could say, hey, your child's ugly, but still be my friend. Okay. So you got to always remember that sometimes they have to deliver a hard message. The CEO may just look at it as an opportunistic trader trying to pump and dump the stock. Senior management, your co-senior executives might say, hey, if this is successful, am I going to be fired? Institutional investors have a different perspective, and you're going to be talking to them, or someone will, and they may be saying, look, if they're not going for the full board or a majority, it may be good to shake it up a little bit. Put in a couple of new directors, get a fresh perspective, different set of circumstances, different communication, different strategy, all that you have to think about now ahead of time before it actually happens. And then finally, for employees, as Lisa said, with the cyber event, with big time litigation, what does this mean for me? Who's communicating to your employees and what are you saying? All this has to be thought about ahead of time. And so now we'll talk about quickly, just hit on the part of big time litigation, the make or break case, the big one. and some of our lessons learned. Lisa.
Yeah, so I won't go into this, but finding an audience for big time litigation, it's usually not a problem if it's a material incident, right? Or a material litigation. You'll have sort of a defined process up to the CFO and with your auditors and definitely to the GC. I'll highlight here on the slide, I'm not going to redo the slide, but there's a lot of different factors that can go into who your audience may be. In addition to the official kind of reporting, you've got to think about some other constituencies that might need to be looped in depending on the facts. In particular, I know CEOs tend to have idiosyncratic interests in cases. And so you may experience this, maybe you don't have this, but at least in our experience, Mike, the CEO had very idiosyncratic interest in matters that weren't material that we needed to make sure we pulled him in on. So consider that. And then we often have the converse problem of finding an audience for an orphan case or a hot potato case. So sometimes cases are really big and they relate to data or incidents that happened a long time ago. Business units have moved on, business unit leaders have moved on. There's no natural owner. There might not even be witnesses left. And there's just a big, ugly matter there that no one wants to take ownership of. Those are the most dangerous for the legal department, right? Because you're going to get saddled with the outcome. You got to find an audience there for an orphan and a hot potato, and you got to communicate, as I said earlier, to make sure someone else understands and there's no surprise.
And you got to find a budget to pay for it.
Bingo. All right.
Yep.
Mike?
Yeah. And so then in terms of the deal, the mega merger, again, just think about your, as you're depending upon your company and where you're sitting, who's going to be most involved in the deal? Is it going to be a business unit like your commercial division versus your consumer retail division? Is it going to be a strategic level stuff? So it's going to be board level material as opposed to business unit level. The one thing I will say that if you think it will be challenged or it may be subject to regulatory review and approval or whatever, there are going to be board minutes, transaction committee minutes, make sure you create a charter. But when you draft those minutes, and we'll talk about it later, but I'll just use it now. Draft the minutes and then run them by your outside securities lawyer and litigation counsel, who will have to defend those minutes in a courtroom. It's better to do it now and get it right and use the correct phraseology than after the fact when it's too late and it's already baked in. I've done that, and it's a good practice always to think about that stuff. Also, remind the executives, remind the directors that if they have email traffic between themselves about the deal, it's not privileged, number one. Number two, they shouldn't be using personal email accounts to conduct company business. They should try to use it through the portal of, if you have an ebook, board book, which I'd recommend highly. But again, these are just little things, lessons learned to think about before you go into a mega deal or mega merger and have it already set up, okay? So that's kind of covered the big items that we handled simultaneously because we gave some thought to it. We had some prep. Other times we just had natural skill and ability that we were fortunate enough to have. So now talking about what got us through this craziness, all right? Well, what gets through you, I think, observing in 22 years of private practice, my years at Sony and Staples, I think there were a few things that were overarching that I learned about. Number one, always remember, fix the problem, not the blame. It is so common for people to engage in the blame game, all right? And my favorite story is the little Dutch boy. He's walking home at night and there's a hole in the dike. And what does he do? Does he sit there and say, oh my God, that's a crappy piece of construction. Who designed that? Who built it? Let's sue him. Let's get an injunction against that guy so he can't build any more dikes in Holland until this one's fixed. No, little Dutch boy sticks his finger in the hole to prevent the flood. And he stays there all night fixing the problem until he's discovered the next morning by the villagers that he saved. All right, but he fixed the problem, not the blame. It is such a natural inclination, particularly for some lawyers, to say like, who screwed up? Or business people say, who screwed up? That's not going to fix anything. You have a data breach, you got to fix it. How it happened, you get to later, okay? But you got to stop the bleeding, start the breathing, as we used to say in first aid in the Marine Corps, all right? Second, I'd rather do it right than right away. Don't compromise yourself. Don't cut the corners because it'll only come back to haunt you. On anything that you do in handling these matters, I'd rather do it right than right away. And I've said it 1,000 times to my people. I said it to fellow executives and to my CEOs, okay? And then number 3, when given a task, look at your watch, not the calendar. We have to move at the speed of business, all right? A good plan executed today is better than a perfect plan executed tomorrow. And remember, we're in-house lawyers. We, in private practice, Lisa and I had the standard of fear of malpractice, right? That was our standard of care.
I still do.
Don't screw up. In-house, if I screw up, I can't get sued for malpractice. I may get fired, but I'm not going to get sued for malpractice. So just remember, good plan today, execute on it, all right? You don't have to be perfect. And then going on to number 4, as we talked about earlier, when you're dying of thirst, it's too late thinking about digging a well. Be proactive, look around the corners. You should sit down, take an hour out of your day and think, what are the big risks? Am I ready for a search warrant raid? Am I ready if the Department of Homeland Security raids our warehouse in West Covina to look for illegal aliens? What are you going to do? Who are you going to call? Number 5, when a customer asks you what time it is, you don't tell them how to build a clock. Lisa talked about this earlier. Efficient communication is the key. In my touchstone that I lived with from the days I was a trial lawyer in Los Angeles to the time that I was in front of the CEO or the board of directors, and that has always been, how would Laverne explain this to Shirley? Okay, it's that simple. Now I know this may be a generational thing. You're gonna say, who the hell are Laverne and Shirley? But they were people on TV, all right? But they kept it very simple. But I'm gonna say this, and I have some of the revelations or revelation that I came to in terms of doing these big cases or all the time. Business people think in terms of Excel. All right, that's if they were a software program, they're Excel. Lawyers, we're Word. All right, we think in Word. But you know where we meet and get together? PowerPoint. That's it. Efficient communication. So how would Laverne explain this to Shirley? It is so important. If you could see Lisa explain a concept or a complex issue in simple, non-pedantic terms to executives, you'd say, yes, that's what I need to have doing. Number 6, always remember, don't micromanage your people, okay? Trust them to do your job. Hire good people and get them to do their thing. And be honest with yourself. Do the assessment. If they need training, hire an advisor to help train them. Okay, did I tell you we do advising too? Oh, anyway, you can do that. And then finally, set and maintain your priorities. One of the most important things to remember, as Lisa talked about with the alligators, to remember your job's to survey the swamp. If you are working from your inbox, okay, you are working on other people's priorities. Now, I'm not saying ignore the CEO or the board or the CFO if they have questions, but you have to maintain the priorities, because if you're running the deal, if you're trying to shepherdize this thing through, not shepherdize showing my age here, exactly, don't work from your inbox. They should be working from your sent box, your outbox, all right? And then finally, what I learned a long time ago from the chairman of Sony, believe it or not, he told me I screwed up once, I made a mistake, and he said, even monkeys fall out of trees. Yes, that's true. Everyone makes mistakes, all right? But the important thing is that we admit them, all right? You learn from them and you don't repeat them. If you take a Dale Carnegie course on how to win friends and influence people, they will say, if you make a mistake, admit it emphatically. Yes, I'm sorry, I made a mistake, but let's move on, because we're going to fix the problem and not the blame. And with that, I'm going to turn it to Lisa for some final thoughts. Lisa?
Thank you. I think we covered some of this, and I want to leave some time for questions. So I'm just going to hit the high note here. In thinking about what's common to all these scenarios and how to really handle a big issue in a company, I think key to it is controlling the flow of information at bottom. That's really what it is. And a couple of devices to do that are, for any big matter, set meetings. If you set meetings, you give people something to focus on, a way to reach us, a way to have communication other than what happens otherwise, which is phone calls and emails, really long ones, often with lots of questions and analyses, all of which are imperfect and problematic in retrospect. may have false information in them or wrong information and may look like you didn't respond to them. So you don't want to do that. You don't want to be on the phone all day with different constituents. Set actual meetings. In data breach, often we'll do 1 in the morning, 1 at night in the early days sometimes, and then we go to one a day, and then we go to 3 a week, and then but we manage the whole internal process in a way to minimize the risk of these sort of one-off conversations otherwise. Second thing is, don't engage in this email traffic that I just described. You're going to have a lot of emails. You're going to have a lot of people trying to paper the record. Use, as Mike says, LDL. Let's discuss live. I just call it the phone. I love the phone. Whatever happened to the phone, right? Love the phone, love live meetings, harder in the pandemic, even sort of like WebEx, although we don't like to record them, of course, folks. Make sure you're checking your configurations, but you really want to have live discussions. No one has time to curate what they're saying and make sure that it's perfectly written with an eye towards litigation. And, you know, Mike and I were talking in advance of this, and we both agree, we've never seen an email that's helpful in litigation, ever, right? Never going to help you. So try not to write them. Try not to write a report for a data breach, for example. Don't write a forensic report unless you have to. Why would you write that? Why is that going to help you? But it seems to be sort of an industry practice. The IT people will say, let's write the report. I always say, why? Tell me, just tell me. So anyway, that's sort of the headline on the final thoughts. Control flow of information, control who's involved, minimize leaks. And if you control the process, you can often get a better substantive result.
Right. I think I can't overemphasize what Lisa talked about earlier, and that is, in any event that you're handling, you establish the cadence of meetings, because that will set the ground rules and the framework for how you're going to approach it. So if it's every day, every Monday, every Thursday, it becomes standard and it doesn't become a hubbub of things. Some other final thoughts, and you've got to sit there today and say to yourself, am I ready to handle multiple thermonuclear events? All right. I mean, it's something that you don't think about. I mean, let's face it. When I started my job at Sony and I started a job at Staples, I didn't sit down at the first day and say, gee, am I ready to handle multiple thermonuclear events? Okay. I know what I could anticipate. I started thinking about it, looking around those corners, and then started to do something about it. But the first thing you say is, once you figure out who you have, is like, do I have the staff that I need? Or do I need to train those people or get more staff or change it out? Then do I have the support that I need? Again, do I have the resources identified to help me through these crises all at the same time? And that's very important. And then also, you know, you're going to think about, these events that occur, the data breach. They're like this thermonuclear event. There's this initial blast onrush of wind, right? Bright, searing light. And then it dissipates, but you have to think about the long-term effects of the fallout, of radiation and whatever. The same thing. Some of these events, they start out as a sprint and they evolve into a marathon and end with a sprint. All right. I think Lisa would say data breaches are just sprints. Okay. But that's the type of thing you have to think of. And I always looked in this chart that I'm going to share with everyone here, is that on the vertical axis, these are sort of like the everyday, the things that you as an in-house lawyer are going to deal with, right? The everyday transaction, run-of-the-mill litigation, business deals, class actions, labor case, whatever, regulatory investigations by the FTC, SEC, whatever, and then a data breach. But see, as it goes up, it gets hotter and bigger and gets more attention, okay? And then finally, you go over and drop down to the horizontal axis, is like, what resources do I have? Staff attorneys, senior counsels. I may have specialists in my department that can handle labor and employment issues or transactional matters. But do you have a Lisa? I mean, you got to have the Lisas, all right? And if you don't have the Lisas in-house, you need to identify the Lisas outside. That's what I always call my Lisas. And then finally, outside experts for the hostile takeover. There's a select group of law firms and lawyers that know how to do activist shareholder campaigns and take over litigation. And, again, take the time and the opportunity and interview, look around, talk around, ask your people. If you belong to a trade association, a great resource for me at Staples was RELA. I would call up RELA and I'd ask them to send out an anonymous email to all the other GCs. Does anyone have a recommendation for a lawyer that can deal with the New Jersey Attorney General's Department of Consumer Affairs. And I would get back through my trade association some recommendations. So if the same law firm shows up 3 or 4 times, that's a good indication they may be able to do the job for you. Again, it's just using your network. So with that, I think we'll turn it back to Taylor for the question period, if we have any questions.
Yes, we do have one.
Oh.
They've asked, which is better, a big outside firm for most all critically important matters, or a collection of expert firms area by area?
Well, Lisa, I'll let you handle that. I'll let you take that from the perspective of one running the litigation function at Staples, right?
Yeah.
And then as the outside lawyer, okay? And then I'll give you my 2 cents from my days at Staples and at Sony. Go ahead,
Yeah.
Lisa.
Yeah. Okay. So I think that it's an excellent question, but I think I think there's the bottom line is you should hire the lawyer, not the law firm. I think you need all the things that I talked about earlier. You need to have confidence in that person's communication skills, their experience, their fit with your client, especially for big ticket stuff. Just going to, you need the name of the law firm. Sometimes that gives you some cover internally, especially if there's a relationship with that firm, but you're really hiring the lawyer. So I think that's number one. But number two, I think you can find a big law firm that has a lot of lawyers that you like in a lot of specialties. In fact, that's why I went to Jones Day. Honestly, when I was in my role, I didn't really know Jones Day, and I came to know them because I hired a series of specialists in different weird areas. I had a procurement specialist. I had someone who could do a Singaporean arbitration. I had, I had a commercial
insurance
in the
coverage.
Netherlands. Yeah, I had all these different things. And it was what attracted me to Jones Day is I found a firm for me where there were enough really great lawyers in enough specialties that was where I started. I would always start there. I'd go to Jones Day. Who do you have? I could trust them to tell me, we don't really have anybody, or more often we do here. And that's where I would start. So I don't think the answer is really either or. It's sort of try to find a firm where they have a lot of specialties that align with what you need, vet who they have. And if there's holes, then I'd go somewhere else. That's sort of the approach I ultimately took.
Yeah. I would say, Lisa, that I was a firm believer at Sony and at Staples that I always hired the lawyer, not the law firm, because I wanted my lawyer to be a trusted advisor. Mm-hmm. And if he was or she was a trusted advisor, I could call them up and say, do you have lawyers that could handle a breach of contract case in San Antonio? And I remember Sony called me, and I was with a Texas-based firm at the time. I was the managing partner of the LA office. And I said, let me find out. And I called my partners in Houston, and they immediately said, Mike, that's Bexar County. And I said, yeah, so what? Well, that's Bexar County, and you got to get a lawyer in Bexar County. And I said, well, okay, good to know. So could you give me the name of a lawyer? And I called back the client. I said, look, we have offices in Dallas, in Houston, but we don't have them in Bexar County. And you need someone in Bexar County, and I'll get you the name, because they could trust me to give them the straight scoop. That's why I think you think about the lawyer there. And if they have someone good, they will tell you. But if it's just one of these things like, oh yeah, Mike, we got 50 of the best lawyers in Houston, they can do anything and everything, that's not what you want to hear. So I found that with the lawyers in terms of certain areas of specialists, you're only going to find them in New York City or Delaware when it comes to, securities or activist shareholder campaign, things like that. And when it comes to, if you're going to have a chancery court action, you better have home cooking covered. All right, I'll say that. Anything else that we have, Taylor?
No other questions.
No other questions. Well, I think, Lisa, you did such a great, thorough job. I hope that people come away with this with one that, take the time and think about assessing yourself and your organization. Be honest and be critical. And even if you do the assessment and you want to pressure test it or run it by, then please, our contact information there. Please feel free to contact me by email or by telephone. I'm here on the West Coast for the next couple of months, and then Lisa as well. If you're thinking about maybe I should look at the marketplace to see if I can get a Lisa for me, then call Bob. All right. But anything else, I guess, that we can give you? If nothing else, I think that
Oh.
should do it, Chief.
Yeah. So Mike and Lisa, thanks so much. It not only is extremely informative, but you made it extremely entertaining, which I think we can all appreciate in days like today. Oh, here we go.
Happy St. Patrick's Day, everybody.
Yeah, there you go. It would not be complete without headgear. Excellent.
So again, just to reiterate, feel free to reach out to any of us. Be happy to help you as best we can. There is going to be a survey, 1-minute survey that you'll receive. Appreciate you taking a minute to complete that. Other than that, thanks for joining us, and we look forward to having you participate in the future. Thanks again.
Thank you, everybody.
Thank you. Appreciate it.